and it's at 7 p.m. in Colorado time. And so we will get started with our meeting today. We have a special guest, John Steggy, and we'll get going now. All right, just so everybody knows, again, first Thursday of the month is the Colorado State USA meeting. You can get in contact with me in regards to this by going to the link. There's a QR code on the right that goes to that same link, or you can text REI USA to 303-648-1378, and I'll get you information on that. In addition, you can email me at rei@ajgpifirm.com. So let's get going. Today, John Steggy will be talking about asset protection and its top strategies you must know to protect your business and personal assets. John, can you come out and talk a little bit about yourself?
Yes, I can. My name is John Steggy. I'm an attorney at law here in Denver, Colorado, and I've been practicing law now since 1990. And I've been fortunate enough to have a lot of experience in helping real estate investors protect their assets and advance their business activities now for 25 years going on. And I've seen all kinds of different strategies that could possibly work to help businesses. And I've also seen what happens when people don't have an asset protection strategy. And so it's that leads me to want to lecture on this. And this is an introductory lecture that's going to be the first of a number of lectures. They'll be posted on all of our social media as well as on this REI. I guess they're going to put this podcast up on their own on the website as well. So you'll be able to take a look at this. This will be only the first of a number of lectures I give on certain topics in real estate. There's a lot of very complex law in this area, and there's a lot of potential risk. Real estate investing is possibly the most lucrative business you can get into, at least in my experience anyway. But at the same time, there's considerable risks and downside, and things can go very badly wrong if you don't know what you're doing and you don't actually pay attention to the proper strategy to use. So basically, this is my contact information. Anybody who wants to talk to me, if you're an investor, if you're someone who's also looking to do any kind of real estate business in the state of Colorado, you might want to give me a call. There's my telephone number, 720-431-1964. That's my cell phone. And there's my hard line, fax, my email, johnsteggy1@comcast.net, and my website and LinkedIn. So those are some of the methods you can use to get in touch with me. At the very bottom of the lecture slides, there's also some of my other websites you can check out. Some of these videos on YouTube as well. Next. Basically, this is just a standard form disclaimer. I'm just giving generalized advice. It may or may not be pertinent to you, especially if you're not in the state of Colorado. You should probably seek legal counsel in your state if you're just doing business in another state, or you could talk to me possibly about what your specific business situation is, but this should not be taken to create an attorney-client relationship, and you shouldn't just act on the basis of generalized advice without a specific advisory, giving an experienced attorney every detail of what you're trying to accomplish and the nature of your business, so that they can make sure that they're giving you the best possible up-to-date advice. All right. The basic concept of asset protection is fairly straightforward and simple to talk about, and its details tend to be complex, but it can be summarized very simple. It's separating business assets from your personal assets. And the concept of it is quite simple, which is we want to encourage investment in the United States. We want to encourage profitable business operations. And in order to do that, the whole concept of creating corporate entities is to make sure that if you are doing business and somehow the business loses money, the worst you can do is that your business assets might be sold off to pay creditors, but your personal assets, your house, your bank accounts, your retirement accounts, your valuables, your cars and boats and other non-business assets would not be used to satisfy a creditor, I mean, and therefore you're not going to get totally wiped out. You're not just risking absolutely everything in order to go into business. So we want to encourage investment. So how you go about that? And basically the whole concept can be summed up as separating your business activities and the financial methods you use to account for those business activities from your personal business. So that entitles separate banking accounts for your business, separate financing. You have to consider whether or not you're going to be personally liable for financing your business. And if so, how do you account for that in order to make sure that everyone understands these are business loans and not personal loans? Accounting for corporate debt and repayment, that's very important. And then there's a whole legal structure that's involved. And that's to create a corporation or a limited liability company or a limited partnership, something along those lines, so that you have legal protection as well. And there's a lot that goes into this, and we'll talk about some of these legal requirements or legal methods that you might use to limit the personal exposure that you might have in doing business in real estate. We'll also talk basically about the types of risk that there are in doing real estate investments. And we'll talk about what level and what kind of protections might generally be in place. Now, I'm not going to get heavily into each of these aspects of things because each of these, for example, partnership, I give a whole asset protection level advanced talk on partnership. There's another one that I'm going to do on financing, including securities laws, and there's just other aspects of real estate that are separate. And so if I were to delve into each of these, we'd be here all night, and I'd probably run out of voice before I got through with it, and you'd probably be bored too. So I'm just going to segregate all of this out into separate little talks, and we're just going to do the basic introduction this time. And if you have separate issues that you might be interested in learning more about a certain area, then there'll probably be videos on that, and you can also just talk to me personally. So the idea behind all this, the legal strategy involves incorporating your business, having corporate minutes that reflect all the basic business operations, having an operating agreement. If you have partners, single purpose entity restrictions, buy-sell agreements, dissolution provisions, lock-in provisions, pro forma and budgetary provisions included. All of this we'll get into briefly. Each one of those topics is obviously a separate issue. And if that sounds all very complex, don't worry about it. First of all, we're not going to delve so heavily into all the minutiae of all these things tonight. And secondarily, what you actually need in terms of all of this depends in part on the level of complexity of your business. If you could, but the basic concept is something that can be said in one sentence. It's to separate those business assets you see on your screen down below, on your left, from your personal assets, your home, your bank account, your personal property, and all of your other personal assets. You can advance the slide.
Perfect. What is an asset protection strategy?
Alrighty. Basically, this is a legal structure. It's designed to prevent potential creditors from seizing your assets. And how this is actually organized in terms of the actual business really depends on the nature of your real estate business, and it depends on the level of complexity. So the first step that I go through when I do an intake is I ask the client to identify what are you doing? What do you plan on doing? What's your business? And there's different types of levels of what people are doing. Some person may say, well, I'm a sole entrepreneur. I'm just doing this myself. I'm buying a house. I'm doing house hacking. Well, I'm just going to buy a house. I'm going to live in the house. I'm going to rent out a room in the house to help me amortize the payment of the mortgage. And that's really all I'm going to be doing. Okay. That's a certain level of potential liability. And so I can identify what are the potential risks involved with that particular level of activity. Another person might come to me and say, okay, I'm a husband and wife team, and what we're doing is we bought a house and we're doing fix and flips. We're going to buy a house and then we're going to renovate it. And then 6 months later, we're going to turn around and sell it, hopefully for a profit. And then we'll just go on to the next project if we find a suitable property. Okay, that's another level. Yeah, it's a partnership. And there are certain risks associated with that. For example, divorce, we'll get into that. So you can see a married couple, joint owners in a business partnership. That's basically what you're doing when you have a husband and wife doing business together and investing in real estate. And possibly they might have a long-term strategy of buying, holding, and renting the property. They might have a strategy of developing and selling it, whatever the strategy is. There are certain risks that are associated with that. So the next level is partnership. This might include one or more partners who are outside parties. These might be friends, co-workers. They might be investors. They might be persons who do a joint venture to get together. One person might say, I have a piece of property. I'd like to develop it, but I don't know the first thing about rehabbing a house and developing and selling it. And then so their friend is a realtor. Another friend might be a construction general contractor. So the three of them get together and they say, I have the house, you've got the labor to renovate it, and you've got the expertise in order to sell it and market it. And so we'll all get together and we'll pool our talents and split the profits. That would be in the form of a partnership with one or more outside parties. And the type of asset protection strategy you'd use in that situation would depend on the nature of the partnership and the nature of the investors that are involved in it. And so you then get into that more complex area of joint venture or complex partnership structure where one or more of the parties may simply be investing money in it. You've got a silent partner, for example, that brings in the impact of securities laws, funding mechanism, waterfall profit structure. And if you don't know what that is, and you're not, I can explain that in a private conversation. Basically, you could get complex joint ventures with other entities and so on at this level. So next slide. Now, this is really the meat of this presentation is really to talk about the different types of liability so that you'd understand what sort of risks are involved and where they might come from, what's involved in all this. For example, there's two different types of basic potential liability when you're in the real estate business. The first of which is internal sources of liability. That is, we're assuming that you're going to put your real estate into a corporate form, and we'll talk about the forms. Let's say you buy a piece of rental property and you put that into a limited liability company. Well, all right, you own it. If you happen to be, say, a husband and wife that did that together, there's the possibility of spousal claims in a divorce. The angry ex-spouse basically seeks the dissolution of the business in order to pay out because they own half of the assets. So that could possibly torpedo the business. You'd have to sell it in order to pay off your spouse. That's a potential source of risk. Now, you may say, well, I'm never getting divorced, but 50% of the people that thought that are wrong. And there's always people who will be looking at this video will be saying, waving their hands, I can speak from experience that not all relationships last forever, just the way of the world. So that is just something that can be dealt with if you are interested in doing so. Another type of potential liability, business creditors. Now, this could be anything from any person you do business with. Purchasers of realty, could be renters, could be contractors, general contractors, subcontractors. It could be the city. This is really the most important source of asset protection. It's basically designed to limit total potential liability to the total of your investment. So if you invested $100,000 in a piece of property, the worst you could do is lose your investment. You're not going to lose your house, your 401k, your other personal assets. So the idea is to shield yourself against personal claims against your assets. This is called piercing the corporate veil. That is to say, a creditor says there's not enough money in this business to pay me what I think the business owes me. I've suffered some kind of loss. I have a claim based on contract or because of some personal injury or something else that I have a claim against this business, and there's just not enough money in the business to pay me. So I want to try and sue the owners of the business individually to try to collect on the debt. The next slide. All right, now external creditor claims. These are people that you didn't ever do any business with. They may not have had any business, but they have a claim against you. These are creditors with whom the person may have done some business, but they don't have remote purchasers in the chain of title. There's no contract relationship between them. You sell a piece of property. That piece of property is then sold to another person. That piece of property is sold to a third person, and so on. Now it's down the chain of title, and someone decides they have a claim, and they go back against the developer. That can actually happen. Creditors with whom the business does, the LLC say, does business, buyers, contractors, suppliers, remote purchasers, or outside parties. This could include neighbors with boundary claims. There could be a title dispute, for example. Your fence is like 1.5 feet over on my parcel. When I did a survey, I see that you now are claiming you're claiming a portion of my land, and so I want to do a quiet title to seize a portion of your lot there. That kind of thing happens. Boundary claims, zoning disputes. There's also business claims against, for say, trespass, like water from your lot pours into my lot and damages my house. That's a claim by your neighbor sues you on that one. Then there's a whole separate set and category, which is probably the most important. When you have more than one member in an LLC, these are personal creditors of a member of the LLC or the LLC itself, members. A member is successfully sued. Let's say one of your partners gets into an auto accident and a creditor of the member tries to force a dissolution of the company to pay the judgment. For example, a personal injury claim or a probate action by one of the member's heirs. You have a partner or even a spouse. You may not know what your spouse's will looks like, but suppose the spouse has a will and the spouse dies, and then the will is probated, and it turns out in the will, spouse left $20,000 to her brother or his brother, and the brother is going to just say, I want my 20,000. And you might say, well, I don't actually have 20,000 right now. We bought this property, we're renting it out, but I can't give you 20,000 right now. The probate heir, the brother, might just say, well, I have a right to this money, and therefore you'll sell the house and pay me my $20,000. So at this point, you've been forced to dissolve the entity and sell off the assets of the business in order to satisfy the probate claim. That's just the type of thing that can happen. There's ways to mitigate that. All right. There's also like personal injury claims and other claims of creditors. Your partner's spouse could be in a divorce and then claim his share of the business, and the only way to satisfy it is to dissolve the business and sell off the assets. There can be protections to prevent that sort of thing from happening. And I've already mentioned probate. In a probate action, the heirs, if there's no asset protection plan in place, the heirs of a partner or a spouse could theoretically try to vote the membership interest or the shares of the company to try to force a dissolution of the business and sale of the business assets. And they can actually go to the district court and ask for a receiver to be appointed to do that and to value all the assets of the business, sell it off, and give them their share. So that could actually wipe out your business or your real estate could be sold in order to satisfy these claims. There's ways to prevent all that. There's ways to have an asset protection plan in place that would limit those types of claims. It would provide the methods for paying them off, and also prevent people from dissolving your business and seizing the assets. All that kind of thing is actually called reverse veil piercing. The creditor actually has no claim against the business per se. The business didn't do there was no business relationship between the person, let's say, that's in an auto accident and has a claim against a member of the business. All that happens is that they had a personal claim, and then that person, the member of the business, becomes personally liable. Let's say someone gets in a car accident and they have $1 million judgment against them. The creditor then turns around and says, what assets do you own? Well, I own a 50% interest in this limited liability company that owns this piece of property. Okay, well, let's seize your assets, let's seize your membership interest and sell it off to pay me my $1 million. That would be reverse veil piercing. Now, obviously, this can arise in the form of a contract claim, breach of contract, misrepresentation, breach of warranty on the sale or of a piece of property. We'll get into that briefly to talk about what that might mean. Tort claim, slip and fall. Somebody just walked down the front yard, slipped, broke their hip, has a hip replacement. Now they're claiming against you. It might be covered by insurance or it might not. That's the sort of thing. Next slide.
So you explained reverse veil piercing, but can you explain what veil piercing is?
Yeah, veil piercing is simply piercing the corporate veil for liability that the business owes. So if you have a business claim and there's not enough assets in the business, you could sell off the business assets, and then there's not enough, you would go after the shareholders individually for the business debts. Reverse veil piercing is where you seize the business assets themselves in order to sell those off to pay off the individual debts of an individual. So it's the opposite. If it's a corporate debt and it's veil piercing, basically the corporation or the limited liability company owes you money. So what you do is that person says, well, what assets do you own? Well, I own a 50% interest in this LLC that owns a piece of property. Okay, well, I'm just going to sell that off, and the business owes the debt. So whatever the assets of the business are, if it owns a piece of property that's worth $100,000, you just sell it off. Well, let's say you owe $1 million. How are we going to get that? Well, the idea is to pierce the corporate veil and go after the owners individually. Well, let's see what else you own besides this business. Because, I had $1 million worth of liability that the business, I think, owes me. And then I'm going to go after you personally, seize your house and sell that to satisfy my debt. So that's veil piercing. Reverse veil piercing is where you're trying to seize the business assets. Veil piercing is where you're trying to seize the owner's personal assets in order to satisfy business debts. That is, debts that the corporation incurred, either because the corporation did business with these people or because they were injured in some way by the business. Okay, does that make any sense?
Yes, Ashley? It does. All right.
So, no, wait a minute, go back.
Oh, go back. Yeah. Apologies.
Yeah. Fraudulent conveyance rules. I'm not going to get heavily into this. There's the types of things that can lead to a veil piercing. There's certain rules about how you have to handle assets, especially when there's not enough money to pay a known creditor. So people might say, well, I'm going to go out of business, so I'm going to transfer all my assets of this business to my wife or my brother-in-law or something. And if that's the case, then a creditor of the business can claim there was a fraudulent conveyance. And there's a 4-year look-back rule, transfer avoidance. Basically, there's ways to grab all the assets back into the business in order to satisfy the creditor. That gets into a very complicated discussion. I'm not going to get into it, but there are certain rules. And if somebody really wants to talk to me, I explain all this stuff to them and how do you avoid those kinds of potential problems. Basically, piercing the corporate veil depends on badges and indicia of fraud. That's a language the courts tend to use. Basically, what they're saying is that the corporate structure is acting as a device to hinder, delay, or defraud creditors. and that's not legitimate. It's not being used for a legitimate business purpose. It's being used to cheat the creditor out of his rightful claim. So we're going to pierce the corporate veil and hold the assets and grab all the assets of the individual person. And there's ways to prevent that from happening. And those ways are basically fall into the category of asset protection strategies. That's basically what we're designed to do, to prevent anything like that from happening, from you losing your personal assets. There's no reason why when you go into business, you should lose your personal assets unless you're deliberately defrauding people or something. And that's just basically what can happen if you don't have the proper corporate structure, the proper asset protection plan in place. So next slide.
Perfect. Here we go.
All right. So basically, these are some of the things that go into a basic asset protection plan. Business name availability. If you're going to do business under the name McDonald's Company and you open a restaurant business, you might have a problem with the McDonald's Corporation. They might not like that. There's like laws about having a name that's too close to somebody else's name. So when you choose the name, you have to be careful how you do that and make sure that it's going to be available in every jurisdiction every state, for example, that you might be doing business in, that name would be available. So if you're going to use a name like Ajax Realty, you might want to check and make sure that Ajax Realty is not only available, but it's not deceptively close to some other Ajax Realty company that might basically be confused. It's actually quite important because you could actually be sued. The other person could be sued and they might accidentally include you, and it might cost you thousands of dollars to convince the lawyer that you're not the right person, that they're suing the wrong person, that you had nothing to do with this transaction. And then you have to, they're unlikely to want to be convinced of that. So you might have to hire a lawyer and go to court to try to prove that. So it's useful to try to distinguish your business and have a unique name that's separate from any other name. And so that's something you have to consider. And that's something I do when I advise the clients about name availability. The next step is really you get in, you file your articles of organization or your for a limited liability company, or your articles of incorporation if you're going to form like a sub S corporation, and then you obtain an employer identification number from the IRS, and you use that to establish a corporate bank account. And that's really important because you're going to want to put every penny that's associated with this business into the corporate bank account. And you're not going to want to commingle those assets with your personal assets, because if you do that, then the court's going to treat the whole big pot, including your personal assets, as one big pot, one big pie that you can use to give it to the creditors. So my very first client when I first got out of law school was this lady who did that, who put all the money from her father's estate into her own personal bank account and then started paying the debts of the estate. They disallowed all these claims, and they she ended up owing $30,000. There wasn't much I could do about it. So you just don't want to commingle your assets. Corporate minutes for all significant transactions. It's simply a matter of documenting all the transactions properly. There's a way to do that. I assist the clients with doing that. And now you need also an operating agreement or a set of bylaws to go with your business. And those include certain things, including management provisions. It goes into member rights, including the rights of dissociated members that might have a lawsuit against them, for example, or they pass away and there's a probate. How do we handle all that? Dissolution and buy-sell provisions, asset valuation methods, lock-in provisions, and a business plan adopted as part of the operating agreement. Now, I have a whole lecture on just that, and I'm not going to go heavily into all that tonight. And frankly, a lot of these provisions may or may not be incredibly useful if you are a sole member. If you just have one person, you're doing business in your own name, it might be possible, for example, for you to use a member managed limited liability company, for example, and you won't need dissolution and buy-sell provisions because there's no one to do that. There might be other things you would want in that agreement, but basically the types of things like lock-in provisions and a business plan, some of that might be less useful in that context. So that's if you happen to have more than one member in the LLC. Some of those things might still be somewhat useful, But it kind of depends on the facts and circumstances of each individual. And those are some of the things that typically can go into an operating agreement. And I explain all that to my clients. I talk to them about what each one of these things is. How do we deal with membership management provisions? Is it going to be a member managed LLC, or is it going to be a manager managed LLC? There are two different types. So which type you use may depend on the nature of your business. Next slide.
Perfect.
I'll say business name availability. I've already spoken briefly about that. Incorporating the business, you're going to want to check your business name in every state that you're doing business. The person responsible for filing is going to be the person that's setting up the business. You need a registered agent in every state you're going to do business with. That person is important because they have to be reliable. That can be anyone, usually over the age of 18, but you want someone reliable that's going to let you know if somebody's contacting you with a threat to sue you. You want to know about that. You have a registered agent for service of process and a business address. So that's somewhere you can receive mail. An LLC has a manager or a member managed LLC, and if it's a manager managed, there's a board of managers. Basically, the law treats all these different forms of business entity as the same in terms of corporate liability. That is, they're all treated similarly to corporations. There are some differences in some circumstances, and we'll get briefly into some of the differences, but generally speaking, case law treats every one of these as a separate entity legally, so that's the whole idea of asset protection. It protects you from having your personal assets grabbed in order to satisfy debts of the business. Next slide.
Perfect. Now, can we talk about the employer identification number?
Yeah, basically, this is an ID number that you get from the IRS if you're going to have employees, I mean. But what this does for you, you may not have an employee. So you're saying, why do I need this? Well, if you're going to establish a corporate bank account, your bank is going to require a taxpayer ID. That's what this is. So you go online and you get what's known as an EIN from the IRS. If you're setting up a LLC, for example, the form is called an SS4 form, and you get a number that you then take that piece of paper to your bank, and then you say, here's my employer identification number, my tax ID number, which is separate from your personal social security number. And that prevents the corporate account from being confused with your personal accounts, and it's used to prevent commingling with your business account. Your personal business account is not your corporate business account. Those things are separate. You don't put, I have a business account. I use that for all my business. Oh, no. Then you've now commingled all your business money. And if you do take money in and out from your personal accounts, you could be commingling your personal assets. All that stuff could then be available for the nice, happy creditor that's just going to seize all your personal assets in any kind of claim. So proper accounting procedures here are absolutely essential. If you don't have a bookkeeper, you're going to have to get QuickBooks or something and do it yourself. Make sure that you account for every penny that goes in and out of that business and where it goes in. If it's your personal money, you have to account for how it's going to be paid back, because those are loans to the business and so on. Respecting the corporate entity is the key name to the game here. That's basically how you make sure that you don't commingle, that you get all creditors and all courts to have to respect the corporate identity. That is, to treat the corporation separate from the business. Now, I mean, for example, there's not one senior executive from a large corporation like, say, Apple, that ever goes to bed at night worrying about personal liability for the corporate decisions, whether Apple owes somebody some money. Why? Because they have a corporate shield, and they have a corporate law department that's separated all the activities of the business from the personal activities of the managers and the board of directors and the officers and of the business. So they don't have personal liability for anything the business does, unless they are fraudulent or something. So that's basically the idea, to set yourself up in such a way that you don't have a personal debt from doing all these things. And that's basically involving respecting the corporate identity, keeping proper books and records, having separate bank accounts, and not commingling the assets with your personal assets. And then also having the proper legal documents to document all the significant transactions, and also to make sure that you've established the corporate identity, you have an operating agreement, you have a set of bylaws, whatever is appropriate. And then you may think this sounds like a lot of extra paperwork, and it is, except that I can tell you that the cost of not doing this is that all of your assets are in one big little pot. And so everything you own is now available to the creditor if you don't do it the right way. And that's really not what you want. When you invest in real estate, there's all kinds of risk, and there's also quite a lot of profit. Just in Denver County alone in the last year, the average increase in value in realty could be anywhere between 8 and 12%, depending on your location. So if you had a $450,000 house, you may have made $45,000 just by owning it in a single year. And it goes up like that routinely. So yeah, it's real profitable, but there's also the potential for risk. So that's basically the idea behind asset protection, respecting the corporate entity and getting courts and creditors to also respect it. Next slide. Okay, corporate minutes. I'm not going to go heavily into this. Basically, the idea behind this is simply to document important transactions. When you're organizing a business, the founders need a set of minutes that authorizes everything that the founders did in order to set up the company. That way, they're shielded from any liability in setting it up. Incorporation documents, the founder action approval minutes, that's what I just mentioned. And then anything you do, if you're going to buy a piece of property, there's a set of minutes that records the decision of the company in order that we're going to do that. Now, you may say, I'm a sole practitioner, I'm a sole member. I don't need it. I just talk to myself. Nope, you need to document everything. And it's not hard to document it. There's a form that we can use. You have to just kind of have an attorney that knows what they're doing. It takes less than 15 minutes usually. And you just have a piece of paper that says, we've approved this transaction, and the board of managers considered it, and then we approved it, and now we're going to enter into a contract, and then we're going to sell the property at the certain price. And away we go. And all the actions of the managers in carrying forth this plan that's been approved by the company are now set forth on this minutes and approved by the members. Well, that's exactly this kind of thing that like Apple Corporation would do if they were going to, say, declare a shareholder dividend, or they're going to buy a $300 million processing plant somewhere. They present that to the board of directors. The directors consider and approve it. There's a set of minutes that say, yeah, you guys go ahead and do that for significant transactions. Significant meaning it's an important transaction based on the scale and size of your business. If it's Apple, that might mean, $100 million acquisitions are probably going to get approved by the board. Maybe a $1,200 buying of paper is not going to be approved by the board of directors of this multi-billion-dollar company. So it just depends on the size of it, what's significant. But basically, that's what you want to do. You want to approve all these significant transactions. Again, this is called respecting the corporate identity, showing that you're doing business just the way a major corporation would do it if they were doing business. You just mimic the kind of actions on a small scale that a big corporation would do. And it sounds like a lot of work, but it's really quite easy once you understand the concepts and you have someone who gives you, like, here's the template that you use, and then you just repeat this, and here you have a set of minutes, and you keep all these minutes in a book. Annual meetings, that's going to be required if you have a sub S with members and you're going to do a profits distribution at the end of the year, for example. You're going to have annual meetings and so on. The corporate code requires that in the case of corporations. It's less formal in an LLC. You don't necessarily have to do that. But you probably want to do that anyway if you're going to take a distribution or owner's draw on your business, just to document what the profits of the business were in 2020, and now we're making a distribution. Here's our year-end statement to the members, even though there's only 2 members. It's a husband and wife. Why bother with all that? It's just documenting all this, and you can show that we've always acted as a corporation, it's going to be much harder to pierce that corporate veil. And that's something that you establish over the lifetime of the business, going back to the founding of it. You can even clean up books where you haven't done that and say, yeah, back 3 years ago, we sold a business, but we didn't actually approve all the transactions. We can go back and create minutes for that and to approve it and so on. So that's all that's involved in that. Also approving annual distributions, corporate employment contracts, doing business with major either suppliers or contractors, or people that, for example, you hire a general contractor to do work on to fix up your house. That's a reason to do that. You put a set of minutes. We're going to enter into this major contract. It's going to pay $20,000 to renovate this property and put in a new kitchen. And we just agree, and the managers agreed that's what we're going to do. So that's basically just documenting the decisions that are being made by the company. Next.
Perfect. Let's talk a little bit about partnerships now.
Sure. Now, I've already mentioned some of this, and I do an entire lecture on partnerships, so I'm not going to get really heavily into this because it's very complex, and it depends on the nature of the business and how many partners you have and what the nature of their relationships are, and whether they're joint venture partners, whether they're equity partners, whether they're sweat equity partners, whatever. So this is where you get into some more a bit more complicated issues. You need dissolution and buy-sell agreements. How do we value this business if we're going to sell it? Because if you have a disagreement between the partners, they're just not going to once they start to disagree, you're not going to get agreement on that. And then you wind up in the district court paying your lawyer $450 an hour to argue about all that stuff. It's just like divorce. And I always say that business divorce is just like regular divorce, except it's more expensive. And the parties, I never loved you anyway. We were just business partners, and now I hate you, and I want you to die, die, die. And so that kind of gets into the attitudes that people have in these business disputes. It's much nicer to have everything written out in advance, like a prenup for your business. And I actually talk about that in my partnership lecture, a prenup for your business. It's just like having a prenup for your marriage. If you have separate assets, if you own your own residence, you don't just go into the marriage thinking, I'll never get divorced. Everything will always be wonderful. And blah, blah. Yeah, and the 50% of the people that think that, according to the statistics, are wrong. You could be one of them. It happens. So, if that kind of thing might happen to you in business too, someone could decide, hey, there's things that happen: death, disability, and business divorce, disagreement. And sometimes the disagreements are things that you could have thought about and talked about in the first step when you were getting involved with this person in the first place. What you might do is say, what's our plan long term? We're going to sell this house, aren't we? I was thinking we'd hold on to it and rent it for the next 10 years. Well, that's not my plan. I don't know about that. So people get into these things, and then they have a dispute afterwards because they didn't talk through. For example, once we establish we do 10 of these deals over a period of 5 years, everything's wonderful, and we're splitting all these profits. I'd like to retire now and get my money out. Well, it may not be a convenient time for you to get your money out. So we have a dispute, and now we're in the district court arguing with each other. That's not good. So basically, you put all this stuff into writing in advance, and it can be hammered out between the partners before they get into a dispute. It's just like doing a prenup if you've got separate assets with your spouse. Like your spouse, for example, has inherited a house from her father or his father. And you don't really want, if you were to get married, stay married for 2 years and then get divorced, do you want your spouse to have half of the value of your house? No. So bottom line, you might say, this is my separate asset, and you have your separate assets, and we will agree in advance when we go into this marriage that our separate assets that we had going into the marriage are going to remain separate, and so on. Anyway, then there's valuation methods. How do we decide what this property's worth? Funding mechanisms and securities issues, those are depending on the nature of the partners. Next slide.
Perfect. Can we talk a little bit more? I know you've already touched on operating agreements, but let's talk a little bit more about it.
Okay. Well, basically, as it was in the previous slide, it depends on the nature of the business. For example, you might have securities issues in a business if you had a member who's just like a silent partner. they just provide money. That's a sale of a security. They didn't participate in the management of the business. You might have to have an exemption from securities registration. But I didn't, blah, 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 blah. I didn't mean for that to happen. Yeah, okay, well, you talk to an attorney and he figures it out. There's ways to get around all these issues. The same thing in you're having an operating agreement. The complexity of the operating agreement depends on the nature of your business. If it's a sole member managed LLC, then it's pretty simple. There's just me, and that's it. I don't need a whole lot more than that. In my business, I just need a basic operating agreement, and it could be member managed, and I'm the member. The organization of the limited liability company, what membership rights there are, is there a board of managers, or which is like equivalent to a board of directors of a corporation, but it's the term that you use when you have a LLC. Or is there a managing member? That there might be two members, but one of them is the manager, and he's going to make the management decisions. And what rights do the members have to vote on all these things, to approve or disapprove the actions of the board of managers or the managing member? How are the capital accounts to be handled? That is, what is my interest in this company? And how is it valued? And can I sell it or transfer it? What rights do I have to do that? Because usually in a closely held business like a limited liability company, if you do it right, the interest that you have in this business is going to be restricted. It's not an open market. You can't just go out and sell your membership interest, and so on. So those are all legal considerations that you have an attorney to just draft an operating agreement that handles all of that. Is it possible or even understood that each of the members of this is going to have an outside business interest? I got a day job. I might be a fix and flipper, and I just want to do this one business with you, Ashley. I want to flip this one house, but then I've got other projects over here that I'm doing by myself, and I'm not cutting you in on that. Well, that could be a problem because at the law, if you form a partnership, it's presumed that you would refer similarly situated business to the partnership. And if you don't do that, it's a violation of the duty of loyalty, considerable potential risk. Your partner could say, hey, you didn't cut me in on this other deal. And then, well, if you put in your operating agreement that we don't have to, that's handled. So the membership information, who are the members, who owns what, that's written down in what's known as an LLC-1 membership information. Just a sheet of paper that says, I owe 50%, you own 50%. This is the value of our investments. And, you keep track of any loans that were made to the business and so on if there's multiple members. And this can also be useful even in the context of a husband and wife. If, for example, the wife puts in $50,000 into this business of her own separate assets, you might want to keep track of that and say, we're going to pay that back. Just things like that. Next.
Perfect.
Okay, now
So
that's veil piercing that I've already spoken about. And honestly, I'm not going to get heavily into this. This is a whole subject matter in itself. But the idea behind that is an attorney that feels like they've been their client has been aggrieved. They're going to be looking at all these different factors that are established by the courts to decide whether they can pierce the corporate veil and hold you personally responsible. And the way some of the business methods that I've talked about, separate accounts, separate accounting, and so on, are designed to prevent this kind of veil piercing. But these are some of the categories. And if these things sound really confusing to you, don't worry about it. Bottom line, this is something your attorney can discuss with you. And tell you how to avoid all these things. It's basic corporate ethics and corporate governance procedures that you establish that will prevent a lot of this. But inadequate capitalization for the type of business, deceptively similar corporate name or identity. I've already talked about that. That's like if you set up a restaurant and call it the McDonald's restaurant, you might have an issue with McDonald's. Usurping a corporate opportunity, I've already mentioned that. The duty of loyalty, holding out theory. That's where one of the members of the business goes out and does something, and then the other members are kind of liable for that decision, even though they may not have approved it. siphoning of funds by the owner, taking money out of the business and not paying the corporate debts, distributions in the vicinity of insolvency. Sounds like what it sounds like. We're going to go bankrupt next month, but what we'll do is we'll pay ourselves $50,000 and take all the money out of the business and leave the creditors with nothing. And then we'll just declare bankruptcy or we'll just dissolve the business. If you do that, that's a red flag that they might be able to avoid. Preferential creditor payments. It's another one. I'm just going to pay A creditor, but not B creditor. So when you do that, bottom line, that could be a problem. You get into all this, it's complex, but I'm not going to get into the details. Transfers to insiders. I know I owe $100,000, but I can avoid all that by taking all the money and giving it to my wife, and then I'll no money in the business. Well, no, that's a transfer to an insider. Your wife, your children, your grandparents, and so on, your brother-in-law, all those people are insiders. So those are potentially fraudulent transfers. I'm not going to get into the fraudulent transfer rules, but that's just something that if you're in business and you wanted to talk to an attorney, it'd be a good thing to do if your business is having an issue of paying all the potential creditors. Next slide. Action items. Basically what to do next: create an operating agreement, create corporate minutes, management rights, contract employees, signature blocks for all corporate documents. We'll get into that one later. Dissolution provisions. Like, when can the company be dissolved? Do we want to lock ourselves in and say, it's going to take 18 months to develop this piece of property? We don't want to sell for 18 months. And then after that, it's going to take us maybe 6 months to sell. So 2 years, we want to lock in, and nobody can get a distribution for 2 years, and you can't dissolve the company for 2 years. And even though there's just two of us. Partnership provisions. What happens if there's a deadlock and a disagreement between the members? You can handle all that. Arbitration, mediation, and agreements to act in accordance with a business plan that we agree to in advance. It says, hey, we agreed, this is what we're going to do. We're going to buy this piece of property. We're going to fix it up. We're going to invest $50,000 in fixing it up. Then we're going to turn around, and 6 months later, we're going to sell it. That's our plan. And if we want to do something other than what's in the business plan, like buy and hold and keep it, we have to have unanimous agreement between the members to do that. And if we don't, then we're going to stick to the original plan. But I don't like the original plan. Let's change it. Well, we have to have unanimous consent to do that. See, it says in the agreement that prevents conflicts. You see, we agree in advance what we're going to do. And if we want to change it, we can change it as long as we all agree. But if one of us says, I want to change it, and the others are like, no, 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 we have a disagreement. Rather than a lawsuit, we can refer to the documents and say, here's what we agreed to. Next.
Perfect. So let's talk about the signature blocks.
Ashley, what happened to the other? Is it after this, the Bergen Simpson slide?
No, I think it got, yeah. Let's finish up. No.
Because I was going to go into that, and I think we skipped it.
Yeah, go ahead and talk about it now, and then
Okay.
we'll get into the corporate, the signature blocks.
All right. Well, basically, signature blocks, it's just how you sign corporate documents whenever you have a business. All right. How to sign in a business capacity. This is for an limited liability company. And this is important because if you sign in a personal capacity, they can sometimes argue, hey, we were looking to you individually to be liable for this thing. You're not even doing business as a company. So when you sign, and this is how every corporate executive from a big company will do it. Company name, limited name of the company by the name of the person, its manager, or if it's manager managed, or managing member if it's manager, if it's member managed. And if it's a sub S corporation, company name, then it should say incorporated, not rather than LLC, the name of the state, limited liability company, or in the case of a sub S, it'll be corporation. Inc. By the name, job title, and that indicates you're signing documents for the company, not in a personal capacity. That's just simple. Just use that on everything. Have letterhead with the name of the company right across the top of it. It's very important that you do that on every single piece of correspondence that you send out, that you identify this is a company. You're doing business with a company. This is not your personal assets. You're not doing business with me personally. You're doing business with my company. So that's just a way of making sure that every time you sign any documents or anything, you make sure that your corporate name is on the title of it and you sign it in a corporate capacity. Next.
Perfect.
Okay, well, that's the, we have a bunch of slides that are missing, right?
There are two
There's
in the
Berg-Simpson
previous
ones.
one. Yes, I'm going to pull those up right now.
Because I knew I was getting ahead of myself.
Perfect. Okay, give me 1 second.
Yeah, I think this was a previous version of this document
So,
that didn't have all that. So you used the wrong version. Okay, yeah, this is basically one, this was intended to be earlier in my talk here, but basically it's a summary of construction defect law. This is another form of personal liability that or corporate liability that you could have. Now, I wanted to emphasize up front that this is one law firm, and it's just one form of potential liability. I've talked about some other forms. This is one that's an important aspect of law. It's just one source of potential liability for real estate investors, and this is just one law firm called Berg-Simpson, and you've seen their advertisements. They're all over television. Good lawyers changing lives. You've seen their ads, and they'll definitely change your life if they sue you. This is from their website. The most frequent disputes in real estate stem from construction defects. In Colorado, construction defect is defined as any defect in the design or construction of any improvement to real property that causes any damages to or the loss of use of real or personal property or personal injury. Okay, so if it's a house you put up on a piece of property and it causes or alleges to cause damage to the owner of it, then they have a potential claim. Generally speaking, there's two types of, I'm reading from their website. Generally speaking, there's two types of construction defects, patent defects and latent defects. Latent defects are ones that may not even be obvious. You may not even have known about them. They appear later, let's say. And defects can range from structural issues, such as foundation problems, simple issues such as crown molding or incorrect paint color. Okay, you painted it the wrong color. Water intrusion damage seems to be a big one that they sue over. Berg-Simpson's construction defects attorneys have been fighting for the rights of homeowners and homeowners associations for more than 20 years, and not just in Colorado. They're a nationally recognized leader in construction defect litigation. So basically, this law firm is they've got, I think, up to 12 attorneys that are doing these cases all over the state, and they're handling hundreds and hundreds of these cases. So, by the way, there's nothing illegal, immoral, or unethical about it. Many of the cases, their clients have been injured in some way by some shoddy construction or some problem that was associated with the development, but not always. Next slide. So basically, this is their attitude. We think that you should get what you pay for. So if something didn't go right, the person that's going to be liable for that is going to be the developer. And we've represented thousands of homeowners, so they've collected a lot of money. Most people do not realize you don't have to be the original buyer of your home to pursue recourse against the builder or developer. If construction defects appear, you could also have a claim against anyone else involved in the construction of your home, from the general and the subcontractors to the suppliers. So up and down the chain of title. So, A, you're the developer, you sold it to B, he sold it to C, C sold it to D, D sues everybody up and down the chain, including the insurance carriers, the builder, the subcontractors, or the suppliers. We care about more than just a check. We'll work hard to get construction defects repaired permanently so you don't end up in the same place. So they're going to mitigate. We want to we help you identify qualified professionals. They're going to call in a team of experts to evaluate the problem, assess repair alternatives, and realistically estimate costs. Because these cases can take time, we also help the homeowners deal with emergency repairs until we can reach some kind of resolution. That means they're going to be out of pocket. They're going to give the homeowner money to fix things up temporarily while they pursue the litigation. Litigation can be costly and time consuming. We try to negotiate an amicable settlement the word amicable, it's open to some interpretation. The defendant, the builder, may not feel that it's entirely amicable. But it's not always possible. We're willing to pursue the lawsuit to its conclusion, including all appeals and the resolution of any lingering insurance coverage issues. So they'll litigate against the insurance carrier, and what they're saying is, we'll go to the mattresses. We will pursue this up on appeal and kick butt. We're not going to back down on this. We're very, very litigious. Next slide. Okay, we promised to get the best results. These are some of their things. 39.5 million, construction defect, foundation, moisture intrusion, 32 million, product liability settlements on behalf of owners with defective windows. We don't know exactly what was defective. Here's one, 26 million for moisture intrusion, shear wall, sound transmission, structure of fill settlement, 18 million for moisture intrusion, construction defect, a separate 1.48 million settlement with the stucco guy. So the stucco applicator got hit with $1.5 million. Next. Here we go, 259 building envelope, grading, drainage, concrete, roof, windows. This gives you some idea of the scope of potential issues. Heritage Green, oh, this one's my favorite. Obtained a 11.67 million jury verdict for damages on negligent construction, negligent misrepresentation, and breach of warranty and breach of fiduciary duty claims against the developer builder and each of their principals individually. So they went after all these people in their individual capacity, and they alleged that they were committing fraud and breach of fiduciary duty. And they won on moisture intrusion and other construction defects claims against the Adams County Homeowners Association. This case was settled on appeal for 11.75 million. So not only did the defendants fight this all the way to trial, they lost, they paid all their attorney fees, and they also paid another $75,000 of Berg Simpson's fees extra on top of the jury verdict just to get rid of this thing while it was on appeal. They finally settled, and they just got absolutely crushed. Defendants did. And that's an example where they just went after the defendants on everything, and they beat the snot out of them. And not only did they get their full 11.75 million in the settlement, but they actually got 75,000 extra in attorney fees on top of that for the appeal, or at least attorney fees and costs and whatever. So anyway, that's just an example of veil piercing. What we talk about is not an academic concept. This one, the individual owners of the developer company were held personally liable for all this. Now, we don't know what was involved. Maybe they were complete fraudsters. We have no idea. Anyway, one thing is for sure, they thought they had 11.75 million more than they wound up having at the end of the day, because they ended up getting personally liable for all that, and however many of them there were, they all got a personal bill for that. They're jointly and severally liable, meaning you could go after them, seize their house. They may be forced into bankruptcy. Who knows? Next.
Perfect. Okay, so that's the example of the case here in Colorado.
Yeah.
The rest of it is stuff that we've covered already. And so this is the contact information for John Steggy if you'd like to get a hold of him. Again, phone number is 720-431-1964. Email is johnsteggy1@comcast.net. There is a link to his website, LinkedIn, Facebook, YouTube, where some of the content of this nature will be published as well. And so I want to thank everybody for coming out, and those on the recording and who were able to watch. And again, this is the Colorado Real Estate Investing USA. So REI USA, we meet on the first Thursday of every month. And my name again is Ashley Jetta Garcia, and my contact information. So to get a hold of me or get more information about REI USA, you can use the QR code on the right. That's the same link as the www.ajgpifirm.com/resources. You can also text REI USA to 303-648-1378. And of course, email is rei@ajgpifirm.com. So I want to thank everybody for coming out tonight, and we look forward to seeing everybody next month. Have a wonderful day.
For everyone who watches this video online or wherever you see it.
Perfect. Any other things we'd like to end
No, I
with,
think
John?
that sums it up.
Perfect. Okay, I'm going to stop recording now.